Right, correct. All right, I'm going to put you on broadcast and I will be muted. Thank you.
Hey, good afternoon, everybody. Thank you so much for joining us. It's 12 o'clock noon here on the East Coast, so we're going to go ahead and get started. My name is Will Creeley. I am the legal director for the Foundation for Individual Rights in Education, a nonpartisan nonprofit dedicated to defending student and faculty rights. Today's purposes, I am wearing a different hat. I have the honor of serving as co-chair of the Education Committee of the American Bar Association section of Administrative Law and Regulatory Practice. I'd like to say welcome, particularly to section members. And if you're not a section member, I hope you consider becoming one. We do a lot of interesting things and put on programs such as this. I'm very pleased to have all 120 of you, no matter your affiliation, joining us for today's discussion. Before we get started, I want to note explicitly that the views expressed on this panel are the views of the individuals expressing them, and the views of the individuals should not be construed to be the views of the ABA or its section of Administrative Law and Regulatory Practice. Again, I will be moderating today's discussion in my capacity as co-chair of the Education Committee. Likewise, my fellow panelist, Joe Storch, his comments on today's panels are his and should not be understood to represent the official position of the State University of New York's Office of General Counsel. Joe and I both want to acknowledge at the outset that FIRE and the State of New York are engaged in the litigation process regarding the final rule we'll be discussing today. Statements today are for educational purposes only and are not representative of the position of our respective organizations in that litigation. We're aiming to ensure that we have time for questions today from the audience at the end. If you got a question for any of our panelists, please use the question and answer feature and we will navigate it to the best of our abilities. So without further ado, let's begin today's conference, the Department of Education's new Title IX regulations, a closer look. In May, the Department of Education issued new Title IX regulations that will dramatically change how the nation's colleges and universities respond to allegations of sexual misconduct. The controversial new changes drew over 100,000 comments and are already the subject of 4 federal lawsuits. They seek to recalibrate institutional obligations against the shifting legal landscape. Among the procedural changes schools must make are including an explicit presumption of innocence, live hearings with cross-examination conducted by an advisor who may be an attorney, new requirements regarding notice and access to evidence, and new requirements regarding investigators and decision makers. We'll talk about all of that here today from a variety of perspectives. So as the new school year seems to beckon in one form or another, and the department's August 14th compliance deadline approaches amidst a global pandemic, I wanted to bring together experts to talk about the regulations and their impact on students and colleges and universities. And to that end, I'd like to begin by briefly introducing our distinguished panelists. I want to note that we have full biographies for each of our experts available on the website. But to put it briefly, and with no disrespect intended by the brevity, I'll begin with Laura L. Dunn. She's a nationally recognized victims' rights attorney and social entrepreneur who has been featured in Forbes, Buzzfeed, National Law Journal, and many more publications. Dunn is the founding partner of the Dunn Law Firm, as well as a published legal scholar and adjunct in Maryland law, an appointed member to the ABA's Commission on Domestic and Sexual Violence and Criminal Justice Section Task Force on College Due Process, and a liaison to the American Law Institute's Model Penal Code on Sexual Assault and Student Sexual Misconduct Project. She's an accomplished litigator who helped win the first ever recognition of a federal victim advocate privilege, as well as an expert witness and consultant working on various campus-based gender violence lawsuits across the country. She's the founder of the national nonprofit Serve Justice. She founded that upon graduation from Maryland Law. Thank you for joining us, Laura. Moving on, Patricia Hamill is a partner at Conrad O'Brien in Philadelphia, where she is chair of the firm's Title IX due process and campus discipline practice. Patricia has represented close to 200 students and professors nationwide in disciplinary matters or related litigation involving more than 70 colleges and universities. Patricia is sought out by groups and institutions and was invited to testify before the U.S. Senate Committee on Health, Education, Labor, and Pensions at the full committee hearing on reauthorizing the Higher Education Act in Washington last April. Finally, Joe Storch joined us. He is an associate counsel in the State University of New York Office of General Counsel, where he serves as chair of the Student Affairs Practice Group. He concentrates his practice on student affairs, intellectual property, and campus safety, and serves as principal investigator on more than $9 million in grants and external funding to support innovations in violence prevention and response on campuses in the community. Joe oversees the SUNY Student Conduct Institute, which offers compliance and best practice training annually to thousands of higher education professionals engaged in response to violence and conduct violations. All right, and with that, let's get started. I'd like to begin today with Laura, given your expertise and your perspective, both as the head of a nonprofit serving victims' rights and now as a litigator and consultant. Figured this would be a good place to start by speaking with you. Laura, what's your overall impression of the new Title IX regulations? We saw them coming down the track fairly early on in the current administration. Now they are here. What do you think?
Well, overall, I definitely find the regulations much more prescriptive than I ever imagined. It was very clear that this administration wanted to put more guidance forward. It was very clear that part of their agenda was ensuring the rights of the accused were solidified some way under Title IX, but I really didn't expect them to get down to the level of detail, nor did I expect them to really kind of limit their viewpoint to that of apparently a large four-year institution or a larger school district, and pretty much neglect all the other smaller educational programs that may not even be housed in an educational institution, or smaller educational institutions that really don't have the kind of resources that this, I think, calls for at various points. I also wasn't really expecting them to not only go over identical areas covered by the Clery Act regulations, and just to back up to give context for the listeners, back in 2013, the Violence Against Women Act reauthorization passed, and I personally was one of several members that worked on that rulemaking committee to propose regulations, and that was a variety of experts representing a variety of constituents, including smaller institutions, and we covered a lot of ground that the Title IX regulations repeat and yet differentiate from. So there's some issues of a direct conflict between now Title IX and Clery Acts. So at least as far as sexual assault in higher education, there's open question marks that I bluntly don't necessarily know how to answer at this point, given the conflict.
Right.
So those are kind of the first takeaways.
Right, that's helpful, Laura, and thank you for providing that context. How do regulations affect the folks that you work with, most particularly victims who may be deciding whether or not to report a violation or an assault or misconduct to their institution?
I definitely think this this regulatory scheme creates some barriers that did not exist before. So one of the first things that jumped out at me is the requirement that the complainant, the person that is allegedly victimized, be part of the institution when making the complaint. And that to me creates a huge challenge in and of itself. I have definitely had a particular case where a student was in an independent study. The assailant was that professor. And so logically, even though it was her senior year, she waited until her grades and graduation to then report, because she feared how that would play out, especially given her ambitions with what that independent study was supposed to do with her future career. And I don't believe that that would be taken per these regulations. Similarly, there's some questions about study abroad. There's always been some question about when study abroad would ever be protected under Title IX. I think that these regulations narrow it beyond what I had previously understood Title IX to do. So Title IX is framed really is meant to prevent those within the United States from having their educational access deterred. The challenge is that sometimes, even if an initial assault happened during a study abroad, obviously students return to campus and there may be a hostile environment, there may be retaliation, there may be subsequent action that is occurring on campus. And I believe that the reading of these regulations, of the most conservative reading, would not allow that on the basis of where the initial incident took place. And I think that departs even from Title IX case law that says the initial kind of location of the assault doesn't matter as much as the connection, the nexus to campus and the hostile environment there. So it's creating more questions than answers in some ways. And another small point that I definitely think matters for survivors, some complainants submit written statements or send an email as a way to initiate a complaint. And there's a requirement that there be a signature. And I just find that a little odd. And I'm sure schools will figure out how to make that a little simplistic, more simplistic for students. But I think anytime you get overly prescriptive about how someone comes forward, makes a report, you're making it harder, not easier. And we really need to encourage survivors to report, because as these regulations show, actual knowledge is now the standard, not constructive knowledge. So we really need survivors to feel comfortable coming forward to even begin asserting their rights under Title IX in this new regime.
Thank you, Laura. Yeah, to that point, it seems as though on the one hand, your characterization of the regulations are very almost micromanaging. They're prescriptive, as you put it. On the other hand, do they let institutions off the hook with regard to narrowing the scope of the knowledge required, for example, or the jurisdiction of a school?
Yeah, so definitely the biggest change that jumped out right away was the change of the knowledge requirement. So under Title IX as a civil liability standard, there was always a requirement of actual knowledge, but we've always seen the department, the Office of Civil Rights specifically, say that constructive knowledge for its enforcement purposes would be sufficient. And this is a severe change from that. And that causes a lot of concerns, because the way I've always viewed it is that the civil standard is intentionally high, right? We don't want everyone running to court, but I've always viewed the department as catching kind of the next level, the earlier stages, and allowing schools to, without penalty of a civil fine or outcome, because there's never been one issued under Title IX, even though there's that threat, have the opportunity to correct paths that may not trigger civil liability, but are clearly on the path to doing so. And so without this constructive knowledge standard, I think it further encourages schools to do what we see in civil litigation, which is turn a blind eye, intentionally not make reporting easily, intentionally not putting information out to encourage reports like who the Title IX coordinator is. I've seen several K through 12 schools in my work not even have Title IX coordinators at all, whether for the school or for the district. And when schools don't have information about what people are supposed to do, oftentimes people just turn to the criminal justice system as a default and don't even know about the rights and options at a school. So there's definitely some concerns with the constructive knowledge being removed, especially for K through 12, where we have often situations of pedophiles working with younger children. And so a lot of times adults will see concerning behavior. And now we're apparently expecting children to articulate and or be able to give that notice to their parents so the parents can articulate. And sometimes that doesn't happen. Sometimes teachers and employees see what victims have not yet been able to come forward and report. So that's, I think, a very devastating change and one that should cause a lot of concern. Another concern is definitely, and I'm going to defer to other panelists to dig into it more deeply, but definitely the religious exemption section, not requiring schools to proactively kind of assert exemptions and waiting until complaints are filed to then allow them to assert such a response. I think it's fair for students who are choosing which kind of schools to go to have that information up front. And full disclosure, I went to a religious high school, so I'm pro whatever educational path people want to choose, but I think there would be a choice whether to go to that school or not based on what kind of protections they would or would not receive. I think that's information parents want to know before they pay tuition. I think that's information students want to know to make sure that they're safe.
Sure.
And then the last big theme, if I may, is just something that I've written recent law article about for Liberty University on mutual no contact orders. I've kind of seen this current administration start to remove the concept of equity and replace it either with equality or, per these regulations, supportive measures. Previously, the administration has always talked about, previously the department has always talked about equitable measures, making sure that the intermediate actions or even remedial actions after an outcome are restoring access to education for those who have lost it. And the framing that's coming out of these regulations, while it's not wholesale rejecting equity, definitely is curtailing that back and eroding it. And I am very alarmed for the sake of civil rights to not have that concept be front and center.
Laura, there's a lot there, and I want to, just for the edification of our audience, the religious exemption, can you explain briefly how that operates for folks who may not work in the sphere who are listening? What do religious schools, what are the differences briefly?
Well, I'm sure everyone generally knows that there are some protections offered under federal law for religious institutions whenever their religious tenets or practices in some way potentially conflict with, say, civil rights or other kind of measures. And my understanding, although I think Joe would probably be better at answering this, is that schools had to proactively seek exemptions. So if, for example, they were discriminating on the basis of sex for certain positions, because of religious values related to their operation, that they could, put that forward, say, these are our tenets, this is why we wouldn't hire a female pastor or chaplain. Right. And that would be kind of pre-recognized before any issue arises. Here, they're basically allowing a school to raise whatever argument it can after a complaint has been filed. So there's no kind of prior notice to anyone.
So it serves as a shield after the fact. I understand. Laura, last question, and I'll make this kind of a twofer. Was the prior administrative regime here working, and do the new regulations do anything positive from where you're sitting?
I definitely, I think anyone who knows my history working on Title IX will know that I was a fan of the previous regime. I myself contributed back as an undergraduate survivor to the 2011 Dear Colleague letter, and I've definitely been part of the rulemaking committee for the Clery Act regulations, which I see potentially undermined by this. So I think a lot of time and a lot of effort by significant experts in the field, as well as passionate advocates and survivors, has already gone into making a bunch of policy. And I do understand that the Trump administration wanted to kind of remove Obama's previous legacy, remove some of that work, and put its own regime into place. But I think what we had, it wasn't perfect, but it was hitting at a lot of issues. And so the very first thing of kind of rolling back the Dear Colleague letter, while some people celebrated that, the biggest loss from that in my mind was really the distinction the Obama administration made whenever something both qualifies as a crime and as a civil rights violation, because schools were sitting back, letting criminal justice system drag on, not be affected, and doing nothing in the interim to really allow a loss of educational access where it could have acted sooner and put more measures and implementations into place. So I've kind of seen the tide change since my activism started. And unfortunately, I'm seeing issues that were issues 10 years ago back on campuses today because of some of these changes.
Right, you've had a front row seat. Yeah, and anything the new regulations get right, Laura, or is it uniformly a step back?
There are a few things that I do like. I overall do not endorse these regulations. I definitely think the lawsuits challenging them make sense, but I do like that they at least acknowledge that certain things could be Clery Act crimes and not inherently be covered under Title IX. And here it kind of says put them through the same kind of practice. So Clery covers 4 specific crimes that are relevant, I think, to Title IX, arguably more, but the main ones are sexual assault, dating violence, domestic violence, and stalking. And I think a lot of schools forget about stalking, and sometimes sexual harassment can overblend with some of those instances. So I like that they reminded schools this is covered, this is the same process, you have to do it for this as well. The challenge with that, of course, is it changes the process that Clery already sets out. Just one small example of the conflict, the Clery Act sub-regulatory guidance, the Campus Safety Handbook from 2016, makes very clear that delays in the process cannot be because someone's advisor/attorney is not showing up, and yet explicitly allows that. So which one wins? It's the same Department of Education, and yet it's saying 2 counter things. And the first one, the sub-regulatory guidance, really was made by experts sitting around in a room hashing this out for a 3-month period, whereas these regulations, while there's tons of comments that have influenced them, have come out with a political agenda.
All right, well, thank you, Laura. We'll return to you in the question segment, but I appreciate all that. That's a good place to start. Turning now to Joe. Joe, you work for a large university system in the state of New York. You are in the Office of General Counsel. You represent institutional interests here. How did the new regulations impact your institutional obligations? And did you have concerns about them during the notice and comment period? And I guess, what does it look like from your vantage point?
Sure. Thank you, Will. And I am so pleased to be with you and with the group and with Laura and Patricia. These regulations are deeply complex. I had substantive concerns during the proposed process. SUNY actually submitted 82 single-spaced pages of comments dealing with hundreds of aspects, which really had no impact, I think, on the final language. The final language very closely mirrored the proposed in some areas, and it diverged in other areas, some of which seemed to be chasing maybe news stories that were out there in the interim. And I will say overall that the department has said, and they've said on webinars and in press releases, they said, well, yeah, it's 2,033 pages, but really all people have to read is the last 30 pages, which is the regulations. And like, you could read that in an hour. They say in the preamble, which you wouldn't know if you only read the last 30 pages, but they say in the preamble, we think this should be like 4 hours of an attorney's time to commit to compliance and 8 hours of a Title IX coordinator's time. And just to put that into context, the 2,000 pages of preamble that come before those 30 or so pages of regulations have a lot of detail. They have almost 2,000 footnotes, 1,970 something footnotes. And just to show you, because I use this every day, we had to print it because I couldn't read it on the computer. This is double-sided, the regulations. And the department said, no big deal. We'll put them out now because there's not a lot else going on, right? It's really quiet times. We're not dealing with any global pandemics. We're not dealing with any economic catastrophes. We didn't have to close down the state university. I mean, that's the stuff of movies, not the stuff we're doing today. You know, we didn't have to convert one of our hospitals to COVID only. We didn't bury 30,000 New Yorkers in the last 6 months. It's a quiet time. So to put into place these very complicated, very novel, very different approach regulations between, say, May 19th and August 14th, no big deal, right? Like, what else are you going to be doing? Watching Netflix, right? We got nothing going on. And I think the world that I live in, especially working in a counsel's office for a gigantic, very complicated university that had to, in a couple of weeks' time, completely shut down, go from 100 miles an hour in one direction to 100 miles an hour in the other direction. First, we had to figure out how to bring home students from 600 programs on all 7 continents in a couple of days. We had to bring them home. People don't even remember that from the beginning of COVID. We had to convert our hospitals. We had people dying. And then to take this on and the complications of it. So I have a lot of substantive issues here, but there's also a bigger issue, which is just a, some people say, read the room. The Department of Education has issued dozens of letters and emails saying, we're going to give you flexibility on this, we're going to give you flexibility on that. Colleges have had to comply with the Clery Act that Laura referenced since 1990. It's older than most of our traditional age students. And the department just gave us a 6-month extension on putting in a report based on data from 2019. That's the same report we've been doing since, you know, I was saying Janet Jackson and Belle Biv DeVoe were the top radio acts when we started working on this. There they can give us flexibility, but here, no flexibility. And the department has said August 14th, we couldn't give one day. Nobody can figure out why August 14th, because in higher education, we always deal with July 1st. My understanding is there's a very big event that's occurring the week after August 14th, and that's what there was an emphasis from the White House that this had to be in place before that big event. That's not traditionally how we do higher education rulemaking, but I guess it's one reason. But the question of, is it arbitrary? Is it capricious? I'm not the oldest person on earth, but I've been doing this for a long time. I'm not sure I've ever seen a regulatory approach, 2,000 pages in just a few months. If this is not the definition of arbitrary and capricious timelines, I guess I don't know. I would have a hard time figuring out what is.
Joe, I think you've won the discussion by name checking Belle Biv DeVoe. So I think part of me wants to end on a high note and call her head. But I want to ask one complaint that I've seen raised quite often, both in the suits and in the commentary, is that the regulations, both as proposed and now with the final rule pending, will reduce the number of complaints institutions like yours see. Is that your expectation? And again, as Laura mentioned earlier, how do you anticipate these regulations affecting students and reporting victims at your institutions?
Yeah, so we'll have two things going on at once. One is the new approach of the regulations, and the second is whatever COVID looks like 2 weeks from now, 2 months from now. It's hard to say. So it would be impossible for me to say what let's hold it in a vacuum and let's do this as a scientific experiment, because in many ways a lot of people are already have a much more of a challenge coming forward. It's one thing to knock on the Title IX coordinator's door in the next building. It's another thing to find a place in your 2-room apartment to make a surreptitious call to the Title IX coordinator to talk about something that you don't want your parents to hear, that you don't want maybe a partner or a family member who might be an abuser to hear. So there are already significant challenges. Our LGBTQI students, particularly our transgender students, many of them had to stay on campus because they didn't have a home to go back to, right? You watch the news and they were saying, look at all these privileged college students. They're all taking college from their parents' basement. Well, that's great if you have a parent's basement to go back to, and many did, but not everybody does. Particularly LGBTQI plus students, we find more do not. Particularly students of color, we find more do not. So it's hard to really tease this out in a vacuum. But I don't think it's a controversial statement to say that part of the department's approach here was in reducing the number of cases that colleges would comply with. You have to look no further than the preamble, where they say, especially in the proposed, they said colleges are going to save $300 and something million because we're going to have so many fewer cases come forward. Now, as Laura would tell you, as my research would tell you, that doesn't mean that we've got $300 million dollars worth of fewer people who are being subjected to violence, subjected to harassment. It means that the narrower standards mean that they're not covered. Now, there's two things going on there. One is that those people are still covered by other laws. In sexual harassment, they might be covered by state laws. In domestic violence, dating violence, sexual assault, and stalking, as Laura referenced, they might be covered by the VAWA amendments to Clery and other state laws. Like in New York, we have a significant state law on point in a number of other states. So they don't go off into nothing, but the traditional expectations of Title IX, 48 years and counting, has been that they have a place at the table protected by Title IX, which says that you cannot discriminate on the basis of sex in education in the United States. So that chair has been removed from the table. So I actually don't think it's a controversial statement to say that we're going to have fewer people come forward. There's fewer people whose incidents are covered. It covers much less geographically. It covers much less behavior. And the behavior that it covers it weirdly, right? There's a gigantic gulf now between the Title VII definition and the Title IX definition, which used to be pretty darn aligned. And so you could say if this is good for Title VII, it's good for Title IX. There's not actually a lot of Title IX case law. Mostly Title IX borrows from Title VII and Title VI. So now we've got a big gulf in the definitions, and you might say, well, it's just a change of or to and to or. Well, but it creates a big gulf. So we are anticipating seeing fewer people come forward. The other thing is the department has said, and they've not been coy about this, that they are putting in additional limitations and due process requirements that exceed any court case on its own, any statutory scheme on its own. I have never seen as much due process in any civil rights case, in any higher education or education case as the department requires in its regulatory guidance, with the purpose, they say there's such a scarlet letter to being found responsible for sexual harassment. They feel that it is worse in some ways than being found responsible for racial violence or for some type of hazing that results in death or dismemberment of a student. The scarlet letter from being accused credibly of sexual harassment is so much higher that they need to add due process. And maybe they're right, maybe they're wrong. It's certainly different than the analysis of nearly every court that has looked at it, and is far and above more than any single court has put together. And so people are wise to that. Well-advised reporting individuals, well-advised victims, survivors, complainants, whatever phrase you use, are not going to go through the process because of some things. And I'll give you one example. The department says you have to share all the evidence with all the parties and their advisors. And they had a comment, and the comment said, certainly you couldn't be meaning that if someone took illicit photos of a student being brutally assaulted without clothing on, if someone took photos of those, certainly you wouldn't mean that evidence. And the department said, absolutely. You're going to have to put it online. You're going to have to share it with the parties, share it with their advisors. But don't worry. You can tell the advisors and the parties to not reshare it. And that's enough. Because that's always worked, right? All we have to do as colleges is tell people not to do anything, and they always listen. That's why I don't have a lot of work to do, right? So all we have to do is tell them not to reshare it, and we've never seen anyone illicitly sharing photographs. And by the way, this came out the same week that a news report came out. I'm not familiar with the facts, but as the news reported, in Utah, in a case of a woman who was slain by an ex-boyfriend, there were some photos that police officers are accused of passing around. So rather than going and interviewing her, rather than going and interviewing the male who ended up killing her, they were passing around naked photos of her on their devices and the like. So the likelihood that a student who is victimized, and part of that victimization is photos of them taken in a state of undress, taken in a state being brutalized, where the college says, oh yeah, well, we're going to have to put them up on this file sharing service and share them with the students and their lawyers, they're going to say, I'm out. That's it. And so that's just one of many examples. That's one where I thought even the department would say, well, okay, that's even a bridge too far. Not for the department. So I don't think it's a controversial statement to say we are going to have fewer students entering the process. We're going to have fewer students completing the process.
Joe, I appreciate that answer. And I want to close, since I think you've referenced the administrative burden with complying by August 14th, and that it poses to an institution, particularly an institution as big and complex as SUNY. So I'll end with a question I posed to Laura as well, just to think it might be interesting to ask all three of you. Was there anything in the previous regulations that wasn't working? And is there anything the new regulations get right from your institutional perspective?
So I think I'm going to answer it a little bit differently than Laura. I think I share her overall view on it. So I'm going to give a slightly, sure. I'll second what Laura said to start. But what I think is happening is that there is a pendulum, and instead of shifting just a little bit, as it did through Reagan and Bush and Clinton and Bush and Obama, now it's going to be shifting wildly. So I anticipate that I'll spend the rest of my career doing red Title IX and blue Title IX. In like, for those who are in the audience who do labor relations, you've got Democratic NLRA and Republican NLRA, and it shifts wildly back and forth based on those appointments. And that's what I'm afraid we're going to see. I don't know that the prior regime was given enough time to work out any challenges, to fix any issues, because really what we had was, we had a 2011 Dear Colleague letter, a 2014 Q&A, we had a 2013 Violence Against Women Act amendments to the Clery Act. Those were trained on, so those became effective in 2015, and they were gone by 2017. So it's hard to be able to say, oh, well, we had the prior regime between, say, July 1st of 2015 and September 7th of 2017. Those are the actual dates. Is that enough time to be able to say exactly how well it was working? I don't think it's enough time. I
Yeah.
think there are aspects of, to your other question, I think there are aspects of the final rule that could be serviceable in a different overall approach. Certainly the notice requirements, certainly the publication requirements are pretty innocuous. They started on an emphasis on training that they really didn't actually go down. I think they could do more in requiring training, because one of the issues, that Patricia finds in her cases is, well, folks haven't been fully trained. That's not, we created a whole institute at SUNY around that. Not to say that everything is perfect, but to say, well, folks need more training. So the department had an opportunity there. I think they wasted that opportunity. So there are things that could be positive or could be at least neutral in a different regime, but as part of the entire thing, they really fall flat.
Thank you, Joe. That's very helpful. It's tough to have just an hour because I could really stretch out with all three of you asking these questions. Patricia, let's turn to you. I'm glad that you were able to make it.
Me too.
Yeah, sorry about the difficulties. Patricia, you represent students and faculty accused of session misconduct in your litigation and in your practice against universities. Let's just take the tail end of what Joe was talking about, the deficiencies in the prior regime, if there were any, and talk about how those have been addressed by the new regulations as you see it. Does this help ensure a fair process for your clients from your perspective?
Sure, thanks, Will. And I'm probably the only panelist that's happy to see these new regulations. I don't think they're perfect, but I'm happy to see a lot of aspects of them. And I think one of the signs that a regulatory scheme, and in some sense, the prior regime was not a regulatory scheme because it was very much guidance through dear colleague letters and other informal guidances that really were driving what was happening on campuses in terms of how Title IX proceedings were handled. And I think you need to look no further than the fact that there were more than 400 lawsuits filed by responding students in 2012 forward, and probably more than that. And those are only the people who could find lawyers who maybe could afford lawyers to represent them. So there's something wrong when you have that many lawsuits against what is going on nationwide at many colleges and universities. So I think that, to me, is what these new regulations were designed to address. What are the issues that were coming up repeatedly in the lawsuits that were challenging adverse findings against responding students? And so what I like about the new regulations, and there was already starting to be through some of the guidance that was issued in 2017, better notice and comment from colleges. And I deal with colleges and universities, not so much K through 12, but in terms of notice, what am I being accused of, and those sorts of things, that had already started to get better. But one of the things that has always frustrated me about representing responding students, and I do represent some complaining students, but it's a very small part of my practice, but is that not every situation requires a formal process. And I know that can be a controversial statement to make in some circles, and not every case, Joe, the one that you talked about in Utah, I mean, that's just horrific and horrible, and should be handled obviously in the criminal justice system as well. But a lot of situations that arise between students on college campuses could be better resolved in an informal or alternative process to a formal, let's have a hearing. I always say once the train leaves the station, at some schools you just felt like this is going to a hearing regardless, when really it might work better if students could have some way to facilitate a less formal process. The new regulations explicitly, allow for that. The other piece, I think, is they strive to balance the supportive measures versus sanctioning a student. And it's a fairly simple idea, which is if you're going to be sanctioned for a Title IX related misconduct, then you are going to be able to have a fair grievance process. And the things that I like about the new regulations are there's no more single investigator model where a single person, and I think that's one of the most problematic aspects, and I'm sure complainants don't like it either. You've got somebody who's sitting and investigating, they're deliberating, and they're deciding ultimately whether you're responsible rather than being a fact gatherer. So I'm glad to see that's gone. The other piece of it is that there's the emphasis on training, I think, is very important. And hopefully, you know, biases that have built up in systems over the years can be eradicated through some good training. I personally like access to records, freer access to records. And I don't discount Joe's concern with students who you can tell them, you know, this shouldn't be disclosed to anybody. That's always a problem. But there are many schools that make it very difficult. And I know Laura has a national practice as well, but there's one institution in particular, well, there's many like this, where they make you come in. If your advisor's with you, you can't see it by Zoom. In fact, you have to handwrite. You can't even bring a computer into the room to type notes. And that's making it so much more difficult than it needs to be for anybody to get help and guidance that they need. And there's always going to be outliers who are, stuff's going to get leaked. That's a terrible thing. And you have to actually take action against students and make it real. If they leak something, you have to really have the you know, repercussions for that. The other part is there's some built-in parts for more adequate time to review records, respond, get ready for hearings. And then finally, of course, the big thing for anybody who represents responding students and that has been criticized greatly is the right, if there is a hearing, that the parties get to cross-examine each other through their representative. And I'm not here to say, oh, that's just, you know, snap of the fingers and that's so easy to manage. That is clearly going to be something that's new and different, but it should be part of the process, because if you are going to find a student responsible for sexual misconduct, it does have life-altering consequences. There are many aspects of these situations that can be better explored through some form of cross-examination. Schools, the decision makers, it's not just for the parties, decision makers should be able to have a truth-seeking mechanism in these processes. And also schools have been dealing with controlling lawyers. For advisors have been in who are lawyers since 2014. Schools know how to, in my experience, tell you how to shut up, you know, stop interrupting, don't speak for your client, or you're going to get thrown out. I personally don't have that style, but I know from other people. So I'm happy to see a lot of what I'm seeing in these new regulations, because I do think it addresses a lot of the concerns that have been raised by the lawsuits over the years.
Yeah, let's talk about that particularly, Patricia, because I both you and Joe have mentioned the litigation that has arisen over the past 9 years since the 2011 Dear Colleague letter, and we have seen the litigation kind of evolve. I feel like I've been referring to it as an evolving area of law for about 7 years now, and we've seen appellate courts weigh in, including some fairly recent rulings. How do the regulations? Joe said he thought that the regulations went beyond the appellate court rulings and the law as it stands now. Do they track, in your opinion? Do these put into the final rule requirements that were being imposed already by the federal courts?
Sure. I think there's two areas. Oh, by the way, Joe, I want to show you what I rely on when I look at the regs. There's my 33 pages, double-sided. Anyway, there are two aspects of appellate rulings, I think, and I agree with Joe. I mean, courts traditionally have had a sort of hands-off in terms of telling a school exactly how they're supposed to conduct anything related particularly to their academic programs, but there was, certainly a hands-off even with the disciplinary side. So you're not going to have cases where courts are going to tell us a university, oh, your code here that doesn't allow for XYZ is deficient, you need to do this, go do it. The place where certainly there was some recognition in the circuit courts was the right to cross-examination. And one of the Sixth Circuit had it most developed, Doe versus Baum, but it was building off of some other decisions as well. And basically the court there said if credibility is an issue, you really do have to have some ability to cross-examine. But the court did not go to the say you can directly cross-examine, you can do it through an advisor or anything like that. It just recognized the importance of it and the right to it. There are some other circuits as well that have recognized it in passing. There's a recent decision out of the Third Circuit involving the University of the Sciences that under breach of contract and fairness provisions went further and basically said you should be able to pretty much directly cross-examine in these proceedings. So the main thing with the regulations is it takes the idea of cross-examination that's been certainly a subject of some circuit court decisions and puts scaffolding around that idea, that issue, and basically prescribes how it should be done to some extent. There's still some flexibility. I think the only other place, at least from my perspective and what I deal with, there was a circuit split to some extent over, could you favor victims over responding students? With, is that a genderized issue? And there was a split among the circuits, the Seventh Circuit and the Sixth Circuit. Oberlin and Purdue decision sort of said, if you've got an unfair process, that certainly could be evidence of gender bias. You had the University of Denver in the 10th Circuit basically saying unfairness to a responding student doesn't necessarily lead to gender bias. I think it's clear under the new regulations that favoring one party over the other can be a basis for gender discrimination, and the colleges and universities have to be very careful about putting in place systems that don't favor one party over the other.
Right. As we approach the final quarter of our talk here, I wanted to encourage folks, if you have questions for our panelists, you'll see a Q&A button down at the bottom of your Zoom screen if you're joining via a web browser. There you go. I see one lighting up already. We'll get to those in a minute. I've got one last question for Patricia. Patricia, as I asked Joe and as I asked Laura, is there anything now, since I think you're generally a proponent of the regulation requirements, is there anything they get wrong? Are these too legalistic? I love the dueling visual aids are very useful in that way, but you say you're not a fan of all of it. What would you change?
I certainly think, I'm not naive enough to think there's not going to be some bumps in the road here as colleges and universities try to implement these procedures, particularly the hearing procedures. That's the newest. The other pieces are built off of the foundation of what's already been there, I think. I think the two places where I have some greater concern is, one is the dual tracks that can occur here. As somebody, now that the Title IX rights of an accused student have gotten more robust under the regulatory scheme, I want, if a client of mine has a complaint against him, I'm going to want it to go into the Title IX processes that are going to be put in place at colleges and universities starting on August 14th. Because otherwise it could be shunted off to just a standard student conduct track. Colleges and universities can still discipline students, even if it doesn't fall in the Title IX bucket, for lots of behavior. And there are usually less robust now protections for students in that process. You can't usually have an attorney advisor in the room with you. You can't even oftentimes have a faculty advisor. So I think that could be problematic in terms of how the regulatory scheme has been set up. The other piece where I think there's going to be some confusion, bumps and whatnot is exclusion of statements. And I think Laura alluded to this where, well, maybe actually you didn't allude to it in this context, but you may have parties or witnesses that have given written statements where their interviews been summarized outside of the hearing process. Now you're in the hearing process. You may have a witness who's not showing up. You may have a party who made a statement in a text to somebody, but now isn't coming in to speak about it or refuses to talk about it. The issue, normally I would say you should exclude those types of statements. Certainly if let me back up. You can't use against a responding student. Some of them have criminal matters pending and they might want to remain silent and not be questioned, and you don't want that to be used against them. But I think in trying to take care of that problem, the new regulatory scheme is very broad, very gray around this issue of what does and doesn't come in, and how do the decision makers take into account if somebody's not speaking. So I think that's going to be a fertile ground for confusion.
And we shall see it play out, perhaps. I want to turn now in our final 10 minutes, and thank you, Patricia, to some of the excellent questions we're now receiving. Ask and ye shall receive, and we have certainly received. So from Megan Downey, and I guess we'll start here with you, Laura, if that's all right. Megan asks about cross-examination. She says, cross-examination traditionally been an important tool in criminal legal processes. Is it an effective mechanism to impose in school adjudications, especially given the psychological effects that sexual trauma can create? What does cross-examination accomplish that submitting questions to a panel doesn't? And I'd be curious briefly to hear from each of you, but let's start with you, Laura, if that's all right.
Yeah, so very briefly, there's actually a circuit split on this exact issue, whether cross-examination is required or not. Sixth Circuit is the most prominent, saying yes, and most recent, I believe, is the First Circuit saying no. You can submit questions to a panel, the panel can ask, and that is what I've seen in the majority of hearings, and that minimizes the trauma. It also minimizes, I would just say, bad behavior that one could expect from, say, a pro se litigant who doesn't understand any limitations or rules on their behavior. I think what the regulations have done is absurd. How can you say an advisor can ask a question but not the actual party? And you're saying schools can provide advisors. What if they don't have any money? And what are the qualifications of that advisor? What if this is a small beauty school program? Like, really, this is not realistic to make sure that everyone has that. So I'm not a fan of direct cross-examination, whether by advisor or otherwise. I think if we're going to make this like a trial, let's just move it into an administrative law court and get it out of schools altogether, because then we'll have rules of evidence, which, by the way, we don't have here, other than relevance, which was written into the regulations at the exclusion of several other different protections that are provided. So that's my 2 cents.
Yeah, thanks, Laura. That's a good place to start. Joe, you have thoughts here, I'm sure.
Yeah, I think Laura makes a good point. The only thing that I will add, Patricia touched on this for a second, if under the final rules, and this is the only place I've ever seen it, I don't even see this in the criminal process, if somebody is not willing to come in and, to the department's words, submit themselves to complete cross-examination, which could be hours and hours and hours, the college is barred from relying on any of their statements they made to law enforcement, statements that they made in another proceeding, statements that they made that were on video. If the person is deceased, then any statement that they made is barred. I have never seen that in the department, in its zeal to protect those who are accused, who they clearly, and this is not a, I think, controversial statement, what they see as their sort of parties and interests, and their zeal to protect them has added this, which is actually really bad for respondents. Patricia mentioned the case of somebody who's facing criminal charges. If they do not want to testify, the college is barred from relying on their denials to law enforcement, their denials to their hall director, their denials prior in the process. In those cases, the college would probably find them responsible by a preponderance of the evidence, because you have somebody saying very convincingly that something happened and the other person's silent, and you can't even rely on things they said prior. And that is a devastating blow to traditional due process before, in my case, a public entity, or in a private college, an entity that has a contract takes a negative action against somebody. The department, in their zeal to try to protect respondents, has accidentally created a huge diminishment of due process rights for respondents who are worried that they might face criminal or other civil cases.
That's an interesting angle. Patricia?
I just think just dealing with straight cross-examination, the problem that the regulations are designed to address is there really was no true cross-examination. Even submitting written questions, one of the challenge, first of all, cross-examination is by nature a give and take and flexible and malleable. And when you have written questions, you're handing them up, a panel chair is looking at them, reading them, oftentimes rephrasing them, changing the meaning. I've had somebody solicit or elicit testimony that I was very careful to ask a very careful question to not elicit a certain angle in this particular situation, and they rephrased it in such a way that it opened the door to something. So I'm a proponent of true cross-examination, the give and take, and these regulations, I think, do accomplish that. And by the way, it's a two-way street. So the respondent's can be grilled if that's the mode that somebody's in, just as much as the complaining student can be questioned about their perspective.
Right. Thank you, Patricia. I've got another question here. I'm going to combine two that are interesting, one from an anonymous attendee and one from Richard Pierce. The anonymous attendee points out that the percentage of sexual assault cases which are actually prosecuted in the criminal system is 2%, which the attendee characterizes, I think fairly, as abysmal. The adversarial process supports the minimization of responsibility and the blaming of the victim, and asked if any of the panelists see value in campuses enlisting the assistance of an independent restorative program in addressing sexual misconduct. And then, somewhat related, Richard Pierce asked, what do you think about compliance with a consortium of schools creates a single entity to receive and process complaints? I've seen some of those models begin to be explored in recent years. So to the extent we can combine these two, I'd be curious for thoughts, and happy to have any of you jump in if you're interested.
Yeah, I'll just briefly comment on, the criminal justice system's failures. I appreciate that someone actually knows that, because my least favorite argument is, well, doesn't the criminal justice system handle this? The answer, no. It really, 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 really doesn't. I've almost never seen an arrest for campus sexual assaults, and that's thanks to gender bias in policing and a lot of norms around, well, when women drink, what else do you expect? And it's really disgusting, quite frankly, what I've seen, especially from campus police forces, in the way that they often don't investigate. I've seen that change at several schools, but it has been an uphill battle to get the criminal justice system to actually take these issues seriously. It's important, and that's part of also why Title IX is being targeted. In my opinion, which is obviously biased towards complainants, I believe that Title IX was being effective, and that is why all these regimes and changes are occurring to make it harder to actually identify people who are committing abuse, which is ironic because we obviously don't want those individuals entering society and harming others. But there really seems to be a move to protect them. So I'll just weigh in with that comment.
Thank you, Laura. Other thoughts on either the idea of taking these cases outside of the campus system, or this regional consortium of schools to process complaints as a collective?
Nothing for me.
Nothing from you. Patricia, you want in on this?
I was going to say, I haven't had experience. I mean, I've certainly heard about the model of these regional consortia, but I haven't had any experience with that. I think restorative justice models, I think I'm all for them. I think they are very difficult to implement. You have to have, and the same thing with informal processes, you have to have both parties be engaged and really truly taking advantage of and participating in the system. Oftentimes it's very hard to make that happen when you have parties who have obviously these are very significant issues in their lives. But if you can do it, I think restorative justice is can be a very powerful tool.
All right, thank you. I think we'll end with one more from Megan Downey. I want to thank everybody who submitted questions, but this one seems to pick up on a thread that we had seen alluded to by the panelists throughout the hour, so I want to go back to it. Megan asks, in the context of informal resolutions as well as formal adjudications, you can speak to the power imbalances that exist between those who've experienced violence and those who've caused harm. I think this does, again, point to the question of direct cross-examination we've been talking about, and how those dynamics might influence outcomes of resolution proceedings, especially for members of the marginalized or vulnerable student communities like undocumented students, LGBT, QIA students, and students of color. I'd be curious just to hear from perspectives in our last 3 minutes here. Power imbalances, do these regulations exacerbate or alleviate how those might impact outcomes?
I'll quickly say exacerbate, because obviously if you're able to afford a good lawyer, you're going to have someone who can cross-examine for you and spend hours and hours with the fact that there's no rules of evidence, no limitation at all, no judge sitting there. I think people that are disadvantaged are those who don't have the economic ability to get someone to come in and assist them. And I'll also just briefly say, regarding restorative justice and informal procedures, there's even power imbalances there. A lot of people promote, especially within my community, this kind of mechanism for justice. I really worry about people in dating violence and domestic violence situations when they're stuck in the cycle of abuse and they've gotten bold enough to report it, but they're being sucked right back in. These other mechanisms used to not be allowed under the previous regime. Anytime there was sexual violence specifically, it had to be adjudicated. I think there was a reason for that, and I stand by that reason.
Thank you, Laura. Yeah, that's helpful. Joe or Patricia?
So I would add, let's think about the economics of the situation. I have a bit of a background in public policy and behavioral economics, and I like to think about the equities. So the department says anybody can be an advisor of choice, and they literally say anybody. And there's examples: the fraternity brother, the mom, another past abuser. So you could have another past abuser of somebody be your advisor doing the cross-examination, and there may be some economic, behavioral economics, psychological economics reason for doing so. You think you're going to have an advantage. Now, Laura and Patricia are both great attorneys. Laura generally finds herself on the side of folks who are bringing forward disclosures. Let's think about their economic interests. Often they're not going to tell their parents. A respondent will very often tell their parents. So the respondent's parents will pay for an attorney, maybe a skilled attorney like Patricia, maybe a local, less, specialized attorney. But there's an economic incentive there. For a reporting individual, for a victim, they will often not tell their parents, and they're not really getting anything out of the process because they can get supportive measures, they can get resources, regardless of whether the person is found responsible or not. They're participating in the process for some elements of justice and the like, and that is not to be diminished. But are they going to spend $50,000 or $100,000, or are their parents going to spend $50,000 or $100,000 on an attorney? Possibly. Much less often. Laura started a great organization that provided attorneys in some of those cases, but not in the tens of thousands of cases that occur across the country. So the incentives are just wildly inequitable. And I'm somebody who represents the exact middle. So I don't advocate for reporting individuals, for respondents, for men, for women, for non-binary. What I'm trying to do is create the most fair process so that everybody can have that equitable seat at the table in order to continue their education. But what I've seen is a situation that has been created that creates wild inequity between those who are on the respondent side and those who are on the reporting individual side. And the department believes that men are more often on the respondent side, and that is what they're seeking to give some protection for.
Joe, I want to give the last word here to Patricia because I see we're at 1 o'clock here on the East Coast. Patricia, do you have final thoughts on this one?
I'm going to say two things about that. Is responding students, mostly young men of color, are disproportionately found responsible in these systems. So there's a power imbalance there. The second is I have represented many students who are LGBTQ who don't want to tell their parents about what's happened to them as a result of that. They've been accused. And the third is that there are organizations like Laura's, Serve Justice, and others who do serve the complaining student population, which is terrific. So I don't think it's black and white. I think it's a very complex issue, like everything involving Title IX.
Like everything. And as you can see, folks, we could go much longer than an hour. I want to say thank you so much to Laura and Joe and Patricia for taking the time today. And thanks to everybody who showed up. Thank you to the folks at the ABA, particularly Ann Kiefer, for helping us facilitate this. And I hope everybody has a restful weekend, and we shall all stay tuned. Perhaps we'll be talking in a year or two time to see what has happened and what has not. So thanks again, folks. Signing off here. This is Will Creeley. Have a good afternoon.
Thanks, Will.
Thanks.